Okay, good morning, everyone. We are going to get started. It's 10 a.m. Welcome to the Lumsden and McCormick Annual Exempt Organizations Conference. This is our first virtual conference. My name is Christine Prue, and I'm going to serve as your host for today's webinar. Before we get to our introductions, I'm going to run through a few housekeeping items. The webinar will be recorded, and once it's available, we will share the link with all attendees. Chat and Q&A are enabled. You can type in comments into our chat, and please put your questions for our panelists and hosts into the Q&A area. We'll be answering questions throughout the webinar, so we encourage you to please submit your questions. We are offering 1 hour of CPE credit for this webinar. Therefore, all polling and survey questions need to be answered. We will have 4 polling questions during the presentation. You will be prompted for each and results will be shared. At the end of the webinar, please complete the short survey, which will automatically launch. The survey will serve as the webinar evaluation and is required again for those of you requesting CPE credit. A CPE certificate will be emailed to everyone who requested it no later than December 21st. A link to the slide deck will be provided in the follow-up email for those presenters that are permitting for their slides to be shared. And now I'm going to be handing things over to our moderator, Sarah Dayton. Sarah is an audit partner specializing in governmental entities, including school districts, public authorities, municipalities, as well as nonprofit organizations. Okay, Sarah, you can take it from here.
Thanks, Christine. Welcome, everyone. We're happy to be able to host our annual Exempt conference as a virtual conference this year, although we miss seeing all of your faces. This session and the one at 11 a.m. focus on employment law. This session, presented by Kim Georger, focuses on the employee side and collective bargaining. The next session will focus on the employer side and will be presented by Lisa Coppola. Lisa will therefore serve as a reference to Kim during this session. Kim is a labor and employment law attorney who has represented employers, employees, and labor unions. Having worked on both sides of labor-related issues, Kim has a unique perspective on employer-employee relations. Kim currently works as a labor relations specialist for NYSIT, where she handles collective bargaining and various contract enforcement issues for public and private sector unions. Lisa Coppola has owned 3 Buffalo area law firms in her 30-year career. She and her team take their clients' challenges to heart, whether they're starting a new business, taking their existing operations in a new direction, or facing a claim. Her law firm is the workplace trainer of choice about New York's sexual harassment prevention laws. The Coppola firm is a certified woman-owned business qualified in New York State. Thank you both for agreeing to join us for 2 sessions today. And Kim, I'll turn it over to you.
Thank you, Sarah. And thank you to your colleagues as well. I'm really happy to be here. I love collective bargaining. I love talking about it. I could talk for 5 hours. I really hope that you all don't have a headache when I'm done today. This is a very dense presentation, so apologies in advance, but Sarah, thank you. Okay, so we're talking about collective bargaining, specifically in the time of COVID. So our roadmap for today, we're going to talk generally about collective bargaining rights and obligations and some related labor relations rights that go along with that. We're going to talk about how COVID has thrown a great big wrench into some of that. Some nuts and bolts for virtual bargaining, which is a terrible, terrible thing to do, but you know, what are we going to do? And then we're going to talk about some best practices for having a good and productive labor relations during this time. All right, so in true attorney fashion, here is my general disclaimer. Although I think I'm right 90% of the time, maybe 95, this is a very unique time that we're in. And what we're doing here is we're taking this unusual set of circumstances and we're trying to shove it into the existing labor laws that we have. And sometimes it works and sometimes frankly, it doesn't. So as I was creating this presentation, I'm thinking to myself, if I was a judge and claimants came to me and said, Judge, here's the law that exists now, here is the facts we're in. You need to apply this law to this set of facts. If I was a judge in some of those situations, I would say absolutely not. It's not appropriate. This is a crazy time. And the laws that exist for our normal day-to-day world, they don't exist here. So, but we don't know if a judge would say that or not, because as always with COVID, we have many more questions than answers. We don't have precedent. We don't have a lot of analogous situations. So what all of that means is Lisa and I are going to give you some wishy-washy answers today. And we ask for your forgiveness in advance. Unlike our Lumsden counterparts, we are very comfortable dealing in gray areas, and reconciliation is not a term that we have in our vocabulary as attorneys. So if you have a specific set of situation, specific facts, and you need a definite answer, I'm sorry, but you're going to need to contact your attorney for that. We're not going to be able to help you. All right, poll question 1. Are you attending this session to earn CPE credit? Yes, no. Oh, this looks like the wrong poll question, folks. Sarah, should I just keep going?
Sorry, everyone. Here's the correct one. It's up there on your screen right now.
All right. So first thing, collective bargaining and some related rights in general. So there are 2 main bodies of law that deal with the relationship between employers and unionized employees. One is federal law, National Labor Relations Act. This deals with private sector employers and their employee organizations. And then the second that we're concerned with is the Taylor Law. This is New York State Civil Service Law, Section 209, et cetera. And this deals with public sector, New York State public sector employers and their employee organizations. There's both on this webinar. Some of these laws are quite similar, some are different. If I am talking specifically about private sector rights, I'm going to tell you that. Otherwise, assume I'm talking about public sector rights, okay? And this specifically is going to be important with mandatory terms and conditions of employment, as we're going to get to that in a little bit. All right, so the first thing I want to say is that all employee organizations have the right and the obligation to bargain collectively with the employer. Also, all employees, whether unionized or not, so every single employee in this country has the right to discuss terms and conditions of employment with his or her colleagues. And I want to stress this because a mandatory term and condition of employment, like one of the most famous and well-known, is safety, right? Unions in this country were built around safety issues. If you think back to the coal miners and the Triangle Shirtwaist Factory tragedy, this is what gave rise to unionism in our country. And so the idea of employees getting together, whether it's at the water cooler or these days on social media, and discussing safety issues in the workplace, it's one of the most fundamental rights that they have. So there's a lot of PR issues around COVID. We want the constituents that we serve to feel safe and to know that we're doing all that we can. And it might be frustrating when your employees feel otherwise and make their feelings on that subject known. And what I want to tell you is that they have the right to do that. And if you were to try and curtail those rights in any way, you might find yourself in an unfortunate situation that you don't want to be in. So best thing to do, you're going to hear me say this a lot over the next hour, the best thing to do is to talk with your employee organizations often and early about all the issues that are happening in your workplace because of COVID. If you have a good relationship with your unions, then the unions are going to be much less likely to go to either internally or externally into the community and talk about the issues that they're unhappy with. Okay, so New York State public employers, you probably all understand and know that when your collective bargaining agreement expires, it doesn't really expire. It exists in perpetuity until the cows come home, until you negotiate otherwise. Private sector employers, when your collective bargaining agreement expires, some terms and conditions in it will extend until impasse. Impasse is the point when you and the employee organization have decided we can't agree, we have to go to impasse. At that point, you can implement your last best offer. Public sector employees, I'm sorry to say that you can't. Just something for you to keep in mind moving forward as you're negotiating issues around COVID. The last thing I want to say about employees having the right to discuss terms and conditions of employment, I don't want you to think that employees can talk in the workplace about anything and everything in any manner that they want. They can't. There is quite a bit of case law from the Supreme Court that curtails an employee's right to speech in the workplace. That's not the topic of this, and we could write a 10-page memo on those cases, but understand that if there are things going on in the workplace, speech happening in the workplace that is very inappropriate, you think it's inappropriate, you should consult your attorney because you might have the right to curtail that speech. All right, so what are we going to bargain over with our employees? Generally speaking, there are 3 things that you get to bargain over: mandatory terms and conditions of employment, the impact your managerial decisions have on mandatory terms and conditions of employment, and most other things that you want to bargain over. So mandatory terms and conditions of employment, the definition of that is quite vague, and so I'm not even going to give you a quote about how to define that because none of it makes any sense. What I'm just going to say to you is if the term and condition of employment you're dealing with impacts any benefit that your employees have, and I'm talking free coffee, parking space, air conditioning in their office, a window in their office, the supplies that they have to use, and then of course, like health insurance, wages, stuff like that, it's likely a mandatory term and condition of employment. And so what that means is before you go changing anything about that, you need to talk to your employee organization first. You guys as employers get to run the show. You have an obligation. It's your purpose is to provide services to your constituents. And so you have to make sure you can do that. And so you can make managerial decisions about how to do that. Just understand that a lot of times those decisions impact a mandatory term and condition of employment. For example, you have the right to assign duties to staff so long as those duties are within the general nature of that staff member's job description, right? However, assigning those extra duties, even though they are within the general nature of the employee's job description, might have an impact on other mandatory terms and conditions of employment, such as will you be extending the employee's normal workday? Are you going to be changing the employee's shift? Are you going to be asking the employee to do things that he or she might need training for? Is there going to be a change in work location? Is there going to be added travel time? Is there going to be a shift in lunch or break schedules? All of those things are mandatory terms and conditions of employment, and your managerial decision has an impact on those. So the employee union, the employee organization, can come to you and say, hey, employer, we're demanding that you bargain with us over the impact of your decision on the mandatory terms and conditions of the staff member's employment. If the employee organization does not come to you with that demand, then you don't have an obligation to bargain over the impact of your decision, okay? For impact bargaining specifically, the union has an obligation to demand to bargain. So if you implement this decision, months go by, nobody raises a fuss, and then all of a sudden you get a charge from PERB seeking for bad faith bargaining, you win because there hasn't been a demand that was made. Conversely, if you make a unilateral change to an existing term and condition of employment that's mandatory, the employer doesn't have to say, hey, wait a minute, stop, you have to bargain with me about this. They can just file a PERB charge if they wanted to. Not that that's the best practice, but because it's quite clear you cannot make unilateral changes to mandatory terms and conditions of employment without bargaining. Okay, so do you have to bargain over everything? No, you do not. You get to determine the manner of the services that you provide the method by which you provide those services, and the extent of the services you provide. So if you're a school district and you're deciding, you know what, we are going to have remote learning and that's what we're going to do and that's how we're going to provide our services, great. You're the boss and you get to do that. Of course, there's going to be some impact bargaining issues there. Importantly, from a financial perspective, right, you get to decide how to spend your money. So if you want to buy 100 new smart boards and lay off 10 staff members at the same time, you can. That's definitely your employer, your managerial right to do that. But there's other issues, of course, surrounding PR and whatnot. I mean, unions are quite vocal when they want to be about issues, which I'm sure you all know. So just consider, even though you have a managerial right to do something, is it the best thing to do? And does the employee organization, and this is going back to our previous slide, does the employee organization have the right to discuss that decision you made, both in the workplace and, you know, on social media or whatnot? The answer might be yes. So, the other thing I want to talk about, your right to do you have to bargain over everything? Staffing levels is definitely a managerial decision. So the creation of positions, filling or not filling vacancies, where you're assigning staff, all of that is your prerogative and you get to make those decisions. I think that is probably one of the most important decisions you're going to have to make during this time is where should staff be working and what should they be doing, and just understand that you get to make those decisions. Okay. So, I hate this slide. So when do you have to bargain, right? We decided what do you have to bargain over. Now, when do you have to bargain? Okay. You are not required to renegotiate items that you have negotiated to completion. This is called the duty satisfaction doctrine. And basically what it means is you have satisfied your duty under the law to bargain with your unions over these terms and conditions of employment. So, and if a union comes to you and says, you know, we need to renegotiate the, you know, our shift schedules because we have too many people in the buildings at one time, given this COVID situation. Must you renegotiate those shift schedules? No, you mustn't. Now, there might be an executive order that limits the amount of people who can be in the workplace, and so maybe you have to, okay? But in that case, but just because a union demands renegotiation, you're not required to do that. You do not have to make any changes at all to your existing CBAs or MOAs. MOAs being memorandums of understanding or agreement, and CBAs being collective bargaining agreements. With that said, that means that you also cannot make any changes without first negotiating with your unions on those issues. The other thing you can't change, and if I could see you, I'm sure at this point I would be seeing a lot of like, oh my goshes. The other thing you can't change is past practices. And you're welcome. I'm going to talk quite a bit about past practices in a little bit, which I'm sure everybody's excited about, especially me. But you cannot change an existing past practice either. And you can't make any change, any unilateral change, which is the change that you make on your own, to a mandatory term or condition of employment. Poll question 2. Do you enjoy negotiating collective bargaining agreements? A, of course I do. It's a great honor to work with our employees and create a harmonious work environment. B, is this a joke? I cannot wait to see the results of that poll question. Okay. All right, that's interesting. Thank you. So now we're going to get into some specific issues that I have seen a lot in my practice that have popped up because of COVID. First, working from home. So this slide is me. Like, this is my favorite image that I'm using in this presentation. I have had so many Zoom meetings interrupted by my toddler telling me that she has to go potty. I can't even tell you. And I'm so impressed with the counterparts, the employer counterparts that I deal with, for being so understanding. And I think it's important to understand also that all of the folks working from home, you probably, many of you in the audience, and certainly many of your employers, have these same type of issues when they work from home. But in general, working remotely is a non-mandatory term and condition of employment, and therefore you can impose work from home decisions as you will. Because the employees are still providing the same services. It's just the method by which those services are provided are changing. But here are some issues that you likely will have to bargain with your employee organizations if you do want your employees to work from home. Importantly, equipment. We're so used to having our offices where our employers have given us all of the resources we need, but we can't necessarily pick them up and move them into our house. So as employers, you're going to have to come up with a way that you can make sure your employees can do their jobs and be productive from home. And then training goes along with that. What type of training do your employees need to navigate all of this work from home equipment and systems, and the platforms that they're going to be using to work with their counterparts and whatnot. I hate technology, and this has been very trying for me. So Sarah and I are friends. We've had a professional relationship for a very long time, and I made her practice with me last night just to make sure I didn't screw anything up on this. So some of your employees, especially older employees, probably have similar concerns. So be mindful of that. Working schedules. Just because your employees are working in their kitchen all day doesn't mean that they don't get a lunch break. So make sure that you're having clear communication with your employees about when those breaks should happen, whether they should be logging off or sending emails, letting people know, like, I'm now on a break. Also, workload. Is workload increasing? And if it is increasing, in what ways? Is it workload increase such that the employee is going to be working beyond their traditional working day? If so, you're going to have to talk about that for sure. Childcare. Now, this is such a strange time. Your employees need to be available to you to do the work that you need them to do. They get paid to work and they need to do the work. Sometimes that's hard, and you have to decide as employers, as an organization, depending on the culture you want to have in your workplace, employee morale issues, how can we help our employees deal with this, the phenomenon of having children running around screaming while they're trying to work? Can we, and do we want to? And technically speaking, if your employees can't be productive because their kids are home, and Lisa and I are going to actually talk about this in like the next slide. Can you discipline your employees? Do you want to discipline your employees? But the show must go on. I will tell you that there's not enough money in the world that could get me to be a boss right now. Your jobs are beyond the pale in terms of what you have to do, the stress you have in your lives. Anyway, all right, Lise. So let's throw this around for a little bit. We've got two employees. They're both great employees. There's a man who's about 25, and there's a woman who's about 42, and the woman's got a couple kids, and the man does not, and they're both working from home now. And the woman is just not as productive as normal. She's missed some meetings. She's had to step out of meetings early. She's not getting reports in on time. Can an employer discipline her, and should an employer discipline her? What do you say?
Great questions. So can an employer discipline her? I think the unqualified answer to that is probably yes. You can see that I said unqualified and then qualified it by the word probably. Should an employer discipline her? That's a grayer area, right? If she's not doing her work and the expectations are clear and have been conveyed in a manner that is understandable to her, then generally speaking, an employer has the right to discipline. Would you agree, Kim?
I would agree, even though I don't want to.
Right.
Right. It is a very great situation with lasting implications for the culture of your workplace, I'd say. And that's like a touchy-feely type thing that, employers should be thinking about. I think, Lisa, what you said that's super important there is that there should be clear expectations given to employees on how they need to manage their work, and what work needs to be done, when it needs to be done, all of those things. Because then as an employer, you have a leg to stand on and say, listen, we were clear, we had meetings, there was policies, there was writings, you saw them, you read them, you signed off on them, and you agreed that you could do it, and you're not doing it. And as much as you're amazing and a great worker, at this point in time, the job's not getting done.
Yeah, and the other thing to remember from the employer perspective is to apply those policies consistently, right? I think it goes without saying, probably every boss at whatever level of management might have some favorites, right? The person who brings in all of the donations to your not-for-profit, for example, right? That great development person. But if that great development person isn't really doing what he or she should be doing, but there's another kind of slacker person who isn't really doing what he or she should be doing, you better be disciplining them both consistently, right?
Absolutely right, for sure.
What are the other sort of risks, right? You've mentioned employee morale, and that's a big deal for sure. But are there legal risks based on your fact pattern, Kim, that this employer should maybe think about too?
Well, so maybe. It depends on your collective bargaining agreement. For many of you, let's say teachers, for example. If the woman in question is a tenured teacher, then obviously there are statutes that protect her from immediate discipline. In order to discipline her, you would have to bring formal charges under 3028 of the education law. For civil service employees, depending on the class, there also are statutes that protect employees from immediate discipline. Before you could remove the employee or discipline her, you would have to bring a Section 75 hearing. Oftentimes, collective bargaining agreements have provisions concerning discipline. You can only discipline or terminate an employee for just cause. How do you prove just cause in a COVID environment?
Right, great point. And by the way, she's 42, you said.
She is 42, yes, and this gentleman is 25.
Right.
So not only is she a woman who has children, familial status is a protected class, she's also older, and therefore her age puts her in a protected class as well.
Right. And our employer, of course, isn't disciplining her for any of those reasons, because she's female, because she's older than the 25-year-old, or because of her familial status. But that wouldn't necessarily stop her from making that claim, right?
That's right. And in a court, if this was a discrimination issue, the employer would have the burden of proving that it had a legitimate reason for disciplining her. And if she's got a stellar employment history, a judge might look at that and be like, what's going on here?
Yep.
Yeah. So anywho, just things to think about before you discipline your employees. Okay, another mandatory term and condition of employment that has been greatly changed because of COVID: employee evaluations. So all employee evaluations, regardless of private sector, public sector, or what type of employees you have, are mandatory terms and conditions of employment. So I'm going to talk generally about APPR, which is teacher and principal performance evaluations. This is codified in New York State law. And then other employee evaluations in general. So non-school related folks in the room, you can just, whatever for about 1 minute. All right, so to my schools. Under the 2019 amendments to 3012, Section 3012 of the Education Law, almost everything having to do with APPR is now negotiable with your union, okay? There are changes that you can make, procedural changes you can make to your APPR plan without having to open the portal and without having SED scrutinizing your plan. And I just had a meeting last night with a employee organization in a school, and I told them, don't change anything right now unless you absolutely have to. This is like what we say for everything concerning COVID. Don't make any changes unless you absolutely have to. Now's not the time, because this is going to end. And when it does end, you don't want to have a plan that is like 90% geared towards remote learning when all of a sudden all the teachers are back in the classroom. So Charlotte Danielson came out with some guidance to her rubric. It's not a new remote learning rubric. There's been some confusion about that. This is guidance and some changes to her framework, right? And basically what she's saying is you can amend this rubric that 99.9% of you use and make it fit for remote learning. And you can do that without having to open the portal, okay? You can negotiate with your unions about what domains you're going to be looking at that impact remote learning or that are affected by remote learning without having to open the portal, okay? If you absolutely must get a variance, you can, but just consider whether it's worth the hassle. Remember, at the end of the day, and I would deny this, okay? I know that we're recording it, but I would deny it and say, like, I don't know, I had some sort of psychotic moment if anybody questioned me on it again. At the end of the day, the only thing that really needs to happen this year is you have to make sure your non-tenured teachers get a composite score, all right? And if that happens, then, we're good. Okay, so now to the other folks in the room and also to school employees who are not governed by APPR, employee evaluations are negotiable. Most everything having to do with them, the procedure, the notices, how many evaluations, how you're going to do it, all negotiable. Think about how you need the process to change in order to get an accurate understanding of your employees' performance during this time. And then sit down and talk with your unions about what changes you need to make those evaluations meaningful and fair given COVID and all of the related issues. And then please, whatever changes you make, put them in writing and make sure there's a sunset clause in that MOA. A sunset clause is just one line that says this agreement expires on June 30th, 2021, period. The changes that you need to make now are not changes that you're going to want to have in place forever. And without a sunset clause, they will remain in place until you renegotiate them, which might be never, or who knows, maybe it will be sooner or not. But the bottom line is this, you just put that one line in there and then it ends. And if you don't want it to end, then you can still renegotiate it with your unions, but you don't want to be stuck with it because COVID is going to end someday. It will, period, it will. So don't be stuck with changes to your existing procedures that you don't want to have forever. Snow days, again, for the schools in the room. This is going to be a huge issue because a lot of you have fully, well, in all of Erie County, you're fully remote at the moment. But even outside of Erie County, you have hybrid models, and who knows what's going to happen with the governor and his ever-changing metrics. So what happens when there's a crazy snowstorm outside and it's a Wednesday, but all the kids are remote? Like, do teachers log in? What if teachers are in the buildings or required to be in the buildings to do their job? Do they have to come to school, or are you going to declare a snow day? Have you guys thought about this? I mean, we think about it all the time because all of our teachers are asking us, like, are we going to have snow days? I don't know. Also, I want you to, before you make decisions, please carefully look at your collective bargaining agreement, because there are going to be provisions in the collective bargaining agreement that will be impacted by your decision on whether or not to have snow days. I have a lot of collective bargaining agreements that say things like, If less than 3 snow days are used during the course of the year, then the Memorial Day holiday will be extended, things like that. So just be prepared. If you're not going to use any snow days, does that mean your teachers and staff and kids are going to have a week off in May? What's your school calendar look like? What are the mandatory or the maximum days of work for your staff? Just take a look. And then also, the human factor, us union reps always think about the human factor. Is a break on a super snowy day a good thing? I don't know. I say yes, but that's me. Here are some other COVID-related issues. Now, I want to, again, remind you that right now I'm looking at public sector employers. This is mandatory, non-mandatory terms and conditions under public sector New York State Taylor law. I'm not saying it doesn't apply to the private sector. It may. There are a lot of similarities between mandatory subjects in the private sector and the public sector, but just check if you're a private sector employee, or double check on this before you go ahead and rely on this. So changes in work location, non-mandatory, but travel, employee schedules, mandatory. Scheduling classes, also scheduling services, non-mandatory, but workload is mandatory. So if you're giving a certain group of employees a heavier schedule, that's fine, you can, but the impacts of that increased workload are mandatory. Your hours of operation, the days on which you operate, the number of employees that you put in each job category, all non-mandatory. But again, there's going to be a lot of mandatory impacts on that. Now, the manner in which work rules and policies are communicated and changes to those work rules and policies are communicated, mandatory. So this is like a very strange area of the law, and this is something that unions hang their hat on quite a bit. It doesn't make sense to me, but it's there, right? You can make changes to, for example, the hours of operation, but the manner in which you communicate that to the employees is a mandatory term and condition of employment. So what do you do in that situation? You're about to make these changes. You need to talk with your union and say, listen, we're going to make these changes. We can make these changes. How do you want to go about communicating these changes to your members? It's as easy as that. And I can't stress it enough. Communication often and early is going to save you so much trouble. All the time, the unions I work with tell me that they feel that their employer doesn't respect them, that they're not respected, they're not given enough credit for the work that they do. And a lot of that, I think, comes down to miscommunications and failure to properly communicate. I'd say a solid 75% of the issues I deal with are because of improper communication, miscommunications, not communicating enough. You don't waive any of your managerial rights because you sit down and have a conversation with your union representatives. They think of them in this instance as partners, even though I'm sure they can be a colossal pain in the butt. I know this. It's going to save you a headache down the road if you can have a good working relationship and have open communication with them. And this is a prime example. Get it out there, like, I'm making this change and I can. You don't believe me? Call your labor relations specialist. They'll tell you, yes, I can make this change. And then let's sit down and talk about how we're going to make it, how we're going to communicate this to the employees, and what might be some other impacts that we should negotiate. And then
I just, it's in the Q&A, but I think it's really just more a comment to go along with what you're saying. And I think this is the superintendent of Newport. Hi, Paul. Newport signed an MOA with all units around this issue. Just for this school year, we offered 2 more guaranteed days in lieu of working remotely during the weather closure. The Board of Ed will approve the new calendar, and it still maintains 181 days of instruction.
Mm-hmm. Good. Definitely important to get out in front of those issues early if you can. And congratulations to you, Paul, for having solid MOAs with sunset clauses around issues. For some reason, none of the districts I work with wanted to do MOAs about remote learning or scheduling or anything. And I wanted to pull my hair out. I pounded my fist so hard and said, please, let's have some MOAs. And my unions were like, yeah, we don't have to. So good for you. All right. safety rules and safety equipment, all of this is mandatory. Like I said before, unions were built around safety concerns. There are a ton of safety concerns with COVID, as you know. A lot of there's guidance, right, from CDC, from Department of Health, and then there's orders, and you need to understand the difference. If the CDC says we think you should do X, Y, and Z, that doesn't mean that you have to do X, Y, and Z. It means they think you should. And if your union says, no, we're not doing X, Y, and Z, we don't want to, that's going to be a problem. And hopefully your unions are not saying that. Hopefully they are wanting to implement the best, safest work rules possible during this time. Of course, with executive orders that obligate you to act in a certain manner, you must. And I think if a union were to argue that an executive order is trumped by a collective bargaining agreement, that's not a case I would want to take. It would not pass the red face test, as Lisa always used to say to me. But please understand that safety rules and safety equipment are mandatory terms and conditions of employment. A lot of my unions have been asking me if my employer is not following the regulations and rules concerning reopening of businesses, what can we do about it? And there's a lot of things you could do about it. What's actually having traction, though, is safety complaints that have been issued to PESH, which is the Public Employment Safety and Health Bureau. So PESH is actually one of the agencies who is actively enforcing rules and regulations concerning safety issues in COVID, just so you know.
Kim, another question. If in the collective bargaining agreement, you have standard days and hours for work, would you have to open the CBA to modify the days and hours due to the pandemic?
Absolutely not. You never have to open your CBA if you don't want to. What you do is you negotiate a memorandum of agreement that just changes that one provision and changes it for a limited amount of time, okay? Opening the CBA means everything's on the table for renegotiation. You never want to do that. But you can absolutely sit down with the unions and say, we've got a problem here. It makes good sense to change it in this way. It's in the employee's best interest to change it in this way. Therefore, we're proposing modifying this limited provision to say whatever you want it to say. Furloughs and layoffs. Non-mandatory term and condition of employment. You can lay off your employees as you need to. You can furlough your employees as you need to. But there are long-lasting consequences to these decisions. So I want to talk with you a bit about some ways that seem to me to make good business sense to manage staff given the financial crisis we're in. And let me be clear, I know that there's no money out there. The unions with which you work, at least the ones that I represent, are, I hope, getting it through their heads that there's no money out there, and the writing's on the wall. So what can we do to make sure that we can provide services that need to be provided, and that when this ends, because it will end, when this ends, the employees that you have invested resources and time and money into training are still there to work for you, right? That's important. If you lay people off, there's no incentive for them to stick around and wait for you to call them back, okay? If you furlough them, and there's a furlough that's negotiated that provides some type of benefit to keep employees around, it's going to be much better in the long run, it seems. So a furlough does not sever the employment relationship. It's employees still are eligible for unemployment on a furlough because there's no work available for them, but they're not completely laid off. You have the ability to offer health insurance, to offer, I don't know, here's another thing that came up. If you have a class of employees, clerical staff, for example, and you don't need them all, and you need to save money, you can design a furlough that keeps everybody employed a little bit but not full time. So half the staff comes in on Monday, Wednesday, Friday. The other half the staff comes in Tuesday, Thursday, and works partial day Saturday, however you want to work it. But this keeps all of the employees, with some money coming in, eligible for benefits under the CBA. Now, a furlough is definitely something that will impact many terms and conditions under the CBA, and you're going to have to be very mindful when you're creating this structure about what you're modifying and how long you need to modify it for. Furloughs can be limited in time. So it can be a month at a time, it could be 2 months, it can be a year, or it could be a week, whatever you need. But it keeps employees around generally, more so than a layoff would. And it saves money. Refusal to work. So an employee is only eligible for unemployment insurance benefits if there's no work available. If you offer your employees other work, they can only refuse it with good cause. So what's good cause? Good cause would be, for refusal, would be if the job would take them outside of the bargaining unit. So if you are offering a teacher, for example, a quasi-administrative position that would take them outside the bargaining unit, they can refuse to take that work and still be eligible for unemployment. Any position that would require an unreasonable amount of distance for travel. So if you have multiple campuses or locations, and the job you're offering is, an hour away from the employee's house, that could be good cause for refusing to work. If the position you're offering is one that offers substantially less wages and benefits, then the employee could refuse that too. So keep in mind. Okay, poll question 3. Which would you prefer? Perfect snow for skiing, Sarah, or a cold beer on a hot beach, Kim?
We've got about 5 minutes left too, Kim, just so you know.
That's impossible. It's not possible. Okay, good, I win. Okay, so nuts and bolts of virtual bargaining. We're gonna go through this really quick. So let me just say, virtual bargaining is not fun. It's no good at all. There, negotiations, 50% of it is human factor. It's looking at your counterpart and trying to understand what are issues are super important to them, what are issues that are not so important. Did I miss something? You can look at somebody's face and you can think, I know that there's something going on that I'm not understanding properly. It's so hard to do that virtually. The only benefit, I think, for the people who I bargain with virtually is that I'm much nicer when I'm bargaining virtually than I am when I'm bargaining in person. And I think it's because I can see the stress on people's faces and you can see the discomfort, and it just makes me nicer. But there's a lot of limitations. There's been some research studies about how people react to all these virtual meetings, and they find that the technology related issues like delays or distortions or people are freezing or blurry, it actually creates a lot of stress, and it creates this phenomenon where people feel very isolated and separated from other people, which long term, who knows? I mean, maybe we'll all be nutcases in 10 years, but concentration is so difficult when you're bargaining virtually. For some reason, even now, like, I think that nobody can see me, and that's why I keep staring at Sarah and Lisa, because at least I know that they can see me. There's human beings here looking at me. And when you're doing something as important and sensitive as collective bargaining, it can be very stressful. Be mindful of the technology and security issues. Is the platform you're using secure? How are you going to deal with caucuses and breakout rooms? Are you sure that if someone is in whatever sort of virtual place you put them, that they can't get back into the main session where you might be? Also, watch for the guy with the leaf blower behind you interrupting your presentation. Set good ground rules beforehand. Now, I just want to say, generally speaking, ground rules aren't always enforceable, so don't like hang your hat on being able to enforce these ground rules. But it is like at the very least, a handshake agreement between you and the partners with which you're bargaining about how things are going to work. When I say visibility, I mean who's going to be visible on the call. In my opinion, everybody who's attending the session should have a plan to be visible. And if you can't be visible, then you don't attend the session. Okay, must you bargain virtually in order to satisfy your duty and obligation to bargain in good faith? The NLRB has said no, but this guidance, it's an advice memo, it's not an actual board decision. This guidance was issued pre-COVID, okay? So we're now in like month, I don't know, 522 of COVID, and collective bargaining agreements have been extended, the extensions are expiring, things need to change. Will a board, a hearing officer, whomever, say that you must bargain virtually? Maybe. Like, this is one of the areas where I could see a court or an administrative agency saying that advice memo is just not applicable here. Any sort of law that existed pre-COVID about this is just not applicable here. So, but what are the alternatives to virtual bargaining? And I want you guys to pay really good attention here, because like I said, virtual bargaining sucks. So if you can do any of this, you should. First, negotiate an extension. This is an extension of your existing collective bargaining agreement. It extends all of the terms and conditions of employment that are in that agreement for however long you want the extension to be. That means wages and benefits. Okay, so if you have a step schedule and the average percent increase each year on step is 2%, in order to agree to this extension, your employees are going to want to extend that 2%. You're going to want an additional 2% on step. You might be able to convince employees to just move up steps, maybe, or not. Same thing with health insurance. Let's say your collective bargaining agreement says for 17-18, employees pay 12% of their health insurance, 18-19, they pay 15%, 19-20, they pay 18%. I guarantee that for 2021, employees are only going to want to pay 18%. They're not going to want to pay anything more if you're negotiating an extension. The other thing is that because of Triborough, if you're a public sector, New York State public sector employer, they wouldn't be required to pay any more than that 18% if the agreement were to expire. A limited reopener. So this is when you bargain your collective bargaining agreement, but you write in a separate MOA, your settlement MOA, that at the end of next year, you're going to reopen only provisions related to wage and health insurance. I guarantee you that your unions are not going to want to have a 3-4 year agreement that deals with wages right now, going out 3-4 years, right? Because this is not good financial times. I don't know how any employer could agree to substantial wage increases out into the future like that. So your employees are going to be looking for a limited amount of time for wage bargaining wages, because they want to come back to the table in a year or two when the dust settles, because this will end, and then negotiate some good wage increases. All right, you can also just agree to a set number of proposals per side. Everybody brings 5 proposals to the table, and that's what we do. Poll question 4, will the Buffalo Bills win the Super Bowl this year? This was not a typo, by the way. Okay, Sarah, I really need to get to past practice. I have to do it, okay? So what is past practice? I told you earlier that you can't change a past practice. I don't think there's any other term in the history of labor relations law that's more misunderstood than past practice. A past practice is a practice in the workplace that's not clearly addressed in the CBA. It's a mandatory term, subject of bargaining. So it's not a managerial prerogative, it's a mandatory subject of bargaining that employees have the right to bargain over. And everybody knows about it, it's existed for a long period of time. So here is a good way to distinguish between past practice, what is and isn't. All right, so because of COVID, you decide you want to give employees the right to combine their lunch break with their 2 15-minute breaks that they have in the collective bargaining agreement. So the effect of that is that employees can take 1 hour break instead of a half-hour break and 2 15-minute breaks. So you do that. And, 3 years from now, you're on a beach somewhere retired with that cold beer in your hand. And there's a new supervisor in your place who wants to do away with this hour-long break, okay? And your employee organization files a grievance and or perhaps a perp charge saying that you unilaterally changed a mandatory term and condition of employment and or you breached the collective bargaining agreement, you can't do it because it's an existing past practice. In example 1, this is what your collective bargaining agreement says. All employees shall receive 2 15-minute breaks and a 30-minute lunch break. Can you lawfully change that practice if this is your CBA language? The answer is no, you can't, because your CBA language is very vague. In this scenario where you're giving them 1 hour of time, a 30-minute break plus 2 15 minutes, you are complying with what's in the CBA. And the arbitrator is going to look at this language and say it's vague. The CBA only says that you have to give them all this time, and you are. So you can't alter the way in which this time is given now, because for 5 years, but you've been allowing them to take a full hour. So now you have to allow them to continue to take that full hour because your collective bargaining agreement doesn't say differently. Now in example 2, it's very clear that the breaks are taken 1 in the beginning of the shift, 1 in the end of the shift. And as an employer, you always have the right to revert back to the clear language in your collective bargaining agreement. And in example 2, that language is clear. So it doesn't matter if for the last 85 years you've been allowing employees to combine that into a 1 hour long break. Because your language is clear in your contract, you can now revert back to that language, and the employee organization can't stop you. Do I have to stop now, Sarah?
I think so. I'm sorry.
No, it's my fault. It's my fault. All right. Well, thank you all.
Thank you very much. I think that was very informative. Paul from Newport says you're giving up all your nice at secrets.
I know. Don't tell anybody.
For all of you as a reminder, the 11 a.m. session kind of continues on with this, with Lisa Coppola as the main presenter and Kim as her resource. So if you can please make sure that you fill out the questionnaire that pops up at the end of this. And then if you can log into the 11 a.m. session, I know we had some problems logging into this one. We apologize. It's using the same Zoom link at the same time. So please make sure you log in at 11, not as soon as you hang up from this one. Christine, anything else?
No, nothing. I think you covered it all, Sarah. I'm going to drop the 11 a.m. Zoom link in the chat right now so everybody can easily reference that, and we will see you all at 11.
I think once this session ends though, Christine, that chat disappears.
Copy and paste, copy the link, and then you can kind of paste it somewhere and go to it right at 11.
Sounds great. All right. Thank you, everyone.